Good morning, everyone. It's my pleasure to kick off our first of a number of panel discussions today, where we are, as has been already mentioned, looking forward and trying to get ahead of the curve. Our panel, and I have some great speakers up here with me that I'm going to let shine, and I'll introduce them in just a second. But I wanted to kick us off by saying we are really hoping for a casual and interactive experience. So as we are up here talking, if people can be thinking about questions they'd like to have answered, that would be great as well. Our topic is about the Internet of Things. And as I was preparing for today, it certainly made me think about, okay, what are we talking about? And frankly, a lot of the marketing research and focus groups show that consumers don't really know what the Internet of Things is at this point. But we have both specific and generalized ideas about what we are talking about. And so, for the smart home or the smart car, you can think about examples where your refrigerator is giving Amazon a call and letting them know that you're out of milk and butter and you need those delivered this afternoon. You're talking about your car being able to communicate with your utility to tell them the status of the car battery, and the utility being able to, in the future, actually use those car batteries as storage spots for when the grid is heating up. And you're talking about things like your trash can being able to call your city and say, I'm full, please schedule a pickup for trash this week. All of these specific things around smart cars and smart homes are around efficiency, convenience, and simplification. But for me, and for purposes of this panel, when I think about the Internet of Things, I really see it as the digital world crossing over into the physical world. And that has real life implications, and certainly has implications for the civil justice system. Over the last 20 to 30 years, when you thought about digital lawsuits, they were about intellectual property, they were about data breaches, they were really about the actual digital bytes that we've been manipulating. What we're looking at now is a circumstance where an actual criminal hack or a flaw in the system can have real life consequences. So if you happen to live next door to a teenage hacker who can get in through your Wi-Fi and your security system, unlock your pool gate, get in, go in while you're away, and slip and fall and hurt themselves in your backyard, who is at fault there? Where did the system break down? How does the civil justice system even sort of analyze those things? So we have some great panelists to talk about what they're experiencing and what they're looking at both currently, because we know that this is Internet of Things is both growing and expanding, but is also upon us. So what are we already seeing, and what are we expecting to see? And so if I can do some quick introductions, we have Megan Brown. Ms. Brown represents corporations in complex litigation and regulatory proceedings concerning technological innovation, consumer disclosures, and regulatory burdens. Megan responds to agency inquiries and develops compliance strategies under a variety of statutes, including the Federal Trade Commission Act, the Federal Communications Act, and state consumer protection law, as well as the U.S. Constitution. We also have Laurie Hane. Ms. Hane is a Vice President and Deputy General Counsel for the Product, Technology, and Law Group in VMware, Inc.'s legal department. Her team supports VMware's products and services, business units, and the Office of the CTO. She's been at VMware for over 5 years. Prior to joining VMware, she was in private practice with Morrison & Foerster, where she was a partner in the firm's technology transaction group. Jim Kaput is a Senior Vice President, General Counsel, and Corporate Secretary of Zebra Technologies Corporation, and has been with the company since 2009. From 2008 to 2009, he served as counsel to the Chairman of the U.S. Securities and Exchange Commission. Prior to that, he was Senior Vice President and General Counsel at the Service Master Company from 2000 to 2007. He began his career at Sidley Austin LLP's Corporate and Securities Group, and he served as a partner in the firm from 94 to 2000. And we also have Phatak, is the Chief Executive Officer and Chairman of the Board for NSS Labs. He is one of the information security industry's foremost thought leaders on vulnerability management and threat protection. With over 20 years of experience, he brings unique insight to the cybersecurity problems facing large enterprises today. A pioneer of internet security, Vic founded Intermedia Sciences Group in 1994, one of the first internet services providers and internet security consulting firms in the US. Intermedia was acquired in 1999 by Teleflex, a global Fortune 500 company, where he served as Global Director of Network and Securities for 2 years before founding Lucid Security. So to kick us off, one of the questions I'd like the panel to answer for us, or attempt to answer for us, as well as anything else you'd like to talk about, is that in this new connected world that we're looking at, there are going to be many layers of players. You have manufacturers, you have network providers, you have software developers and data managers, if we want the Internet of Things to function as envisioned. As hackers move their targets from databases to devices, how do we think liability, and in what form, should be apportioned along that chain that would be fair to consumers and businesses? Megan, do you want to start?
Sure. I mean, I think the question sort of presupposes that we're in a world where we're able to discuss liability between different corporate actors, but I think we kind of need to take a step back and ask ourselves, what is the tort system in this context? What is its goal, right? Is it to improve product security? Is it to just punish bad actors? And to me, I think Lisa's comments at the outset were spot on in terms of litigation is not a great way to either improve security going forward or to help a very complicated ecosystem figure out who should be doing what. It's slow, right? The decision makers are not expert, far from it. And there's a lot currently of definitional uncertainty in what we're even talking about with the Internet of Things. The layers you describe are so much more complex going forward than even the smartphone, with which we're now somewhat familiar. But even there, it's an incredibly complicated system. So I would like to stop and think a little bit more prosaically about what is the tort system going to fix or address in IoT. Right now, the tort system really looks at punishment and compensating consumers. And we've seen some cases get out ahead in the IoT space that aren't really looking at tangible harm. They're sort of speculative cases about harm that might happen. So I think that's a conversation, to pick up on the previous speaker, sort of a social policy, legal policy kind of question about not letting the litigation system get too far out ahead of where we want incentives to be, because as we can discuss, the litigation system's incentives are really anathema to collaboration and speedy response. They have a chilling effect on companies, and I think communication that will be hard on innovators to continue to improve security. So I'm sort of dodging your question by saying, I don't know we're ready to talk about who should hold the bag for liability, because whether you're talking managed services, unmanaged services, little consumer IoT, or big sort of industrial sensor IoT, it's such a large space. I feel like we have to have some preliminary discussions. That's my way of dodging your question on who should hold the bag.
Fair. Well done. Very lawyerly. Yeah, but Jim, please.
Yeah, let me add a few thoughts to that. First, Zebra, what do we do? In IoT, we play in what we call the EAI, Enterprise Asset Intelligence space. We're in business to business, business to government. And when we think about things like liability, we don't worry about standing. All of our customers think they have standing, and they have standing, right? You resolve it often in different ways. So what does Zebra do? We're the world leader in ruggedized mobile computing in the enterprise space, in scanners, hands-free, handheld scanners. So and also what you would call barcode printers, thermal printers. They can have RFID tags in them, things like that. So we allow our customers to capture, to transmit, to store data. It can be on their systems, our systems. We work with lots of partners as well. And we have interesting products. So let me give you a couple of real examples. Every NFL player in every game is tagged with 2 active RFID tags, and they're tracked every moment of the game, throughout the game. They can be used for in-game experience, which you haven't seen yet. But they're used by coaches after the game to analyze what is going on and to see who's playing well, where, against whom, and for coaching. A lot of the teams have that in their practice facilities as well. We've developed a couple of interesting products that are going to allow for a retail space to compete in omni-channel, not just we have a geographic footprint and people come and shop here, but they can shop online, pick it up on their way home. Gives you 24/7 visibility into everything that's tagged on the store floor. It's trying to get to the place where a company that is like an Amazon, where everything is tagged and we know where it is in the warehouse because no 16-year-old is walking around moving things there, right? They can fulfill right there, but you might get it in a couple days instead of in a couple of hours, right? But that raises questions around the functionality in that product has also video. It has Wi-Fi. It has beaconing around privacy issues for customers coming in, things like that. So we worry about that. And then a little farther out, because that one we announced a couple months ago, working on heads-up displays to give warehouse people visibility. If you think of the movie Minority Report and creating an augmented reality where I know, based on what I'm looking at, and a screen in front of me, that's the augmented reality of what's on the shelves, what's in the box, things like that, because it scans what is there. And now I have hands-free ability to, I don't have to scan it, put it down, pick it up. I already know what everything is there. And that's something we're working on. We've gone from, in a couple of years, a kind of unwieldy goggles to a really kind of cool, almost looking sunglasses type situation. So for us, though, a couple years ago, we embarked on a program basically to get our voice out there to make sure that in this emerging technology spaces that the B2B, B2G perspective is heard as well. We solve a lot of our problems in different ways. I think we have some different liability exposures and issues. They're very similar, but solved differently around privacy, cybersecurity, things like that. We have to worry about insurance as well for us. So getting our voice out there was a program we started, and so actually for us to have the U.S. Chamber then form CTAC and say, we're going to get a more general business voice out there to accommodate not only B2C, which of course is the one we're all familiar with, and even as I saw this program get created, I saw the focus is on B2C because that's what we read in the newspapers every day. That's what we see in Section A. I like to say we're in Section C, but it's still real and behind the scenes there. So, sorry I'm going on a little bit, but it is a different perspective that I want to make sure gets heard, and as we think about it, it's a little more nuanced or subtle and segmented, I guess, than we often talk about it. But same kinds of issues around product liability, warranty claims, negligence claims, fraud, except that we also worry about indemnity, statements of work, and things like that.
Great. Laurie?
So just to go back to your question about where does the liability and where is it going to end up falling, I agree the fundamental question is what liability you're trying to manage down the risk, down the chain, but I would say the existing sort of legal instruments are blunt and not nuanced and don't take into account all the complexities of what we've just heard from our opening speaker. VMware, my company, is one of those companies in sort of the infrastructure chain. And we manage liability to our B2B customer, accepting some liability, but ultimately pushing it down and resisting. Just think about IoT application in the cloud. Everybody knows what those terms are, and the cloud liability terms are: we don't take liability, we don't take third-party liability. You may have a limitation of liability. That's what you spent with us, which is obviously a fraction of what ultimately the app developer and the device manufacturer are going to face in the consumer setting. And so, ultimately, sadly, I think for Jim, the liability ends up on, you know, the B2B or B2C or the B on the other side. And as your point is, the customer's always right. They always have standing. And so how are you going to manage that with respect to your customers by amount of contract? But I think in terms of the supply chain, that's ultimately where it ends up.
Vic?
Thanks. So, just despite the bio, which was very long there, NSS Labs, we're an independent test lab. Our customers are enterprises, not the vendors. So let me start by saying that. I've got a very interesting view on things, which is the experience of when are people ready to accept that they've got a problem, right? You know, it's just like anything else. There's a lot of different phases where you go from there may be a problem, denial, right? Finally, you have anger, acceptance, et cetera, right? And right now, we're at a point where I think things are going to, you can talk about liability, where does it reside? I think to your point that it's very difficult to pinpoint, but what's going to end up happening is that we're going to have a loss of trust, to the point that was made earlier about Steve Jobs. The single biggest thing he did was trust, right? I think we're going to have a loss of trust as the attacks have been moving from, I'll call it, you know, for example, we had I forget the name of it right now, but there was all the wireless video cameras that were then being used as part of a botnet to do DDoS attacks. That doesn't really hurt if I have one of those cameras, it doesn't really hurt me, it hurts somebody else, right? It's similar to like click fraud in the advertising area, right? Advertisers pay too much, right? They're not getting what they're paid for, but as a consumer, if my PC is infected with click fraud, I'm not really harmed, right? Where's the harm, where's the damage? What's been happening now with ransomware is we're seeing the shift towards, and it's a dangerous escalation, because before it was I'll call a victimless crime that was being committed by folks wherever in the world. And the criminal organizations have managed to find ways of siloing people so nobody feels responsible or accountable if a medical device is held ransom and somebody dies, right? So then, you know, the bottom line here is I think that we're going to, before all the liability and torts and all the rest of it catch up, the consumers are going to lose confidence in these devices, number one. And then number two, somebody's going to come along like Apple did and say, I can own it end to end. I can create an ecosystem, right, with accountability. And that's who's going to win, right? So I think of it from more of a technology perspective of what's that evolution. And whoever does that and decide they want to win, they're going to provide transparency. They're going to work with folks like us to make sure that the enterprise customers or end user consumers actually know that they take privacy security seriously. But I think we're going to be, right now there's a lot of euphoria about what's possible. I think things are going to get a lot worse before they get better. And in terms of where does the liability sit, I think it's probably going to, again, I think the trial lawyers are probably going to be happy, but there's going to be a lot of misery for everybody else along the way.
Well, and it's fascinating as that switch sort of occurs. What I'm expecting to see on the legislative and regulatory and legal front is sort of well, certainly the criminals did the bad act, but we can't really fine them or sue them. So, you know, whoever was supposed to defend against the criminal act is who's going to be liable for it.
Right. Well, and so as an example, let's just say that you're a venture capitalist, and somebody comes to you and says they can create a smart sensor for something but they want $1 million. Or next guy comes along, man or woman comes along and says, I can do it securely, but I want 3. Mm-hmm. You haven't yet proven that you can gain traction, that anybody even wants to buy it. Which is the intelligent, rational venture capitalist can invest in? They're going to put the 1, not the 3, right? Because there's not yet been proven that there's an appetite for that product to begin with, right? So again, I think we have systemic and cultural issues that they're not, you know, of rational, good, you know, it's not bad actors, it's rational thought process that leads to an outcome in the short term that I think is going to be, does that make sense?
Sure.
Yeah.
Yeah. So I'd like to turn a little bit to, do the panelists have a thought about what sort of policies or best practices or any other method you can think of should we be thinking about and encouraging to make sure that all these different entities in the chain are working together to minimize risk and increase security. So if you have, I think very disparate groups are going to be providing services and products into a home. You have your service providers, you have the manufacturers, you have the software developers. How should we be trying to encourage cooperation to minimize risk and liability? Vic, do you want to start on that one?
Sure, and then I don't want to hog the time here. I think first is transparency, right? I mean, of course, I'm a testing lab, that's what I believe in, transparency. But I think that as soon as you have transparency, then you can have trust between parties, right? And then once you have that trust between parties, you can truly start talking about interoperability and not having, because oftentimes security breakdowns are where different systems meet, for lack of a better description, right? So let's just say you have an IoT in the cloud, you've got a cloud system that's managing my pool, right? But the actual device is at my house, right? And that cloud system is sitting on VMware, right? That lack of accountability of what happens if, not to pick on you, but what if there's a VMware infrastructure issue, right? That can take advantage of a vulnerability in the application in the cloud that normally would not be accessible, right? It's sort of the series of events. And that's where I think if you start talking about transparency in terms of how do you foster companies working together, I think that the first and foremost it would be, and I can't stand compliance, accreditation, things like that. And we do assessments because I just think that you end up with a very low bar. But I think that having audits, just like you have financial audits between business partners before you do certain deals, if there are technology audits, I think that's probably the first step to having people working together. So in terms of what could Congress or some sort of legislative action be, it would be if you're doing certain, I don't know how you would measure materiality, but if you have a material transaction that's going to affect a certain number of people, that you have a third-party audit, not us, somebody, whomever it is, that then gives all the parties confidence that they know what they're getting into.
Yeah, I think
So
that was
let me give
Yeah.
it's a nice segue into a discussion about what VMware and where we are thinking about IoT, which is thinking about helping to manage security and transparency, interoperability, and openness on what we would call edge or gateway devices, right? So you have your data center or your public cloud platform on which you're running your application, or you're pulling the data, but in fact what you're doing is trying to manage devices on the edge before the data even goes out to the internet. So that's something that's an initiative at VMware, but really to address and to facilitate some of the concerns you've raised, which is, what do you audit? What standards are you developing? Really, you don't want to certify and standardize all the devices. There's going to be millions and millions of them. Where do you want to set the standards? Maybe not exactly the data center either, because that's a very big and complicated thing. So focusing on edge and gateway devices is, at least from a technology perspective, where VMware's putting some of its efforts and thinking about.
This is one area where I think litigation really can have a chilling effect on the kind of transparency and cooperation that would actually help the ecosystem, because if you get down to a human level, the fear of litigation can affect things like company A needs to talk to company B about a vulnerability that they've found, or some issue related to a product on which they're collaborating, or in which a software component is a part. That communication is not going to be privileged. It's not going to be subject to a confidentiality protection. And it's the kind of thing that the plaintiff's bar would like to get. And I think what I've seen is, engineers and the smart guys and women who build stuff don't and shouldn't think about things with a fear about downstream consequences. I think that has a chilling effect. And I worry that when you get a government request or a subpoena or you're in litigation, what happens? You send out a litigation hold, and now you're worried about both internal communication and communication with third parties, when you should be in the security space talking about what's the problem, how do we fix it, I disagree about fixing it, this update is ready now. I mean, there's a lot of communication that goes on that, as someone who counsels companies, I don't relish being part of discovery. particularly when there's not been harm. So I think we have to give thought to how, and this would be a place for policymakers to really think about, if they're going to be creative in trying to encourage information sharing that everyone talks about as being so vital, what very creative solutions can they put in place to try and grease the skids for those communications to happen, not chilled by fear of down the road liability for the thing you didn't catch or the thing you didn't think was a vulnerability but came in through your vulnerability disclosure program, for example. That's sort of my reaction to your transparency point.
Yeah, it's, I mean, in terms of, right now information sharing is focused primarily on threat intel. If it shifted to product vulnerabilities and company-to-company sharing, and there was some government protection, for, you can't be sued if you're sharing this information based upon that. I think that probably would be pretty helpful. I could see that. I could see that working, and also for third parties, because that's one of the problems is that you've got third parties disclosing, and then companies saying, "Okay, well, we're going to sue you now," right? And it's so.
Jim?
So a couple things. One, to respond to something Megan just said, and really for the ILR part of this presentation. So I just read this blurb the other day, and having been, and I guess still am, a securities lawyer, it was around the Supreme Court accepting a case on private rights of action for known events, uncertainties, right? So an MD&A type disclosure for a public company like Zebra. And I didn't get into the details. It was just a blur, but it got me thinking, because I'm coming to this thing as well, and thinking, that's a real issue if there is a broad private right of action when you have, and we've struggled with that occasionally over the years at Zebra, where some event occurs, a business issue that you got to resolve, and we have to sit around and decide, is that something that MD&A requires disclosure on? It hasn't yet hit our income statement or balance sheet or anything like that, but it's a forward-looking concept there, and so there's a number of things going on. I think you need to police that one, Lisa, and make sure that the Supreme Court comes out right on that one. The other is, and this is something that Vic said early on, I hadn't thought about this, is, for Zebra, we, less than 100 million of our revenues is, we own it end to end, right? The NFL solution that I talked about earlier, we kind of own that one. We capture it, we store it, we transmit it for them, we give it to them, and then they can use it in how they decide how to train or coach or their players. And there's a couple other solutions like that, but most of the time in our whole business model, in fact, over 80% of our sales are through and with partners, right? So we have a very complex business model working with lots of stakeholders, and frankly, I haven't been able to think through and identify a lot of the, I guess, how do we work together in the future? I mean, I know we got to do things like best practices, otherwise you're going to get charged with negligence or something in the way that you've established information security standards, things like that. So we want to keep up with that, so we monitor cases, we monitor enforcement actions, we monitor statements and guidance given out by, for example, FTC or something like that. So it's a whole new world for us in trying to figure out, because we're not going to change our business model and just create one end-to-end solution that we own. There's so many opportunities and possibilities out there. We want our devices, if that's all we play in that solution, to sell our devices into that solution, right? Sometimes we will provide the whole solution, but so as a practical matter, it's for Zebra, we can't kind of shrink down what we do. We want to keep expanding and play fully in IoT, or as we call it, enterprise asset intelligence.
So one of the things in Michael's presentation earlier that struck me the most was when he was talking about the exponential curve of AI and the ability of folks to even keep up with those developments. I guess my last question for the group is I mean, as these systems get more complicated and multi-layered, I mean, what chance do we think the courts have or consumers have to even figure out where fault lies and who should be doing it? I mean, I think we know that they will continue to decide, but how how accurate and fair that process is something that I think we need to be thinking about. But do folks have any thoughts or comments about what the civil justice system needs to do to try and fairly adjudicate these complicated issues?
I mean, one area, there are still some states who don't have or have not adopted the more rigorous standards for scientific evidence. And I think that's the kind of example of how certain justice systems, certain states need to really think about how to bring their evidentiary rules and other approaches up to sort of modern standards. And I really think there's a great opportunity for CTEC and ILR and the industry generally to come in and talk about the need for creative solutions here, whether it's special masters that'll deal with certain things, but something creative, because I don't relish the idea of a jury trying to figure out whether a particular vulnerability was material or exploitable. I think you'd end up with a painful battle of experts that is going to be further and further, away from lay people's expertise. It also does show the importance of continuing to educate the public, which is something that my clients have been saying to policymakers. You can't just look at the manufacturers or the software industry to fix stuff. Users have a role to play in basic cyber hygiene, being sophisticated about what they're doing, to understand the products and services that they're using. But I think this could be potentially so different that states and the federal courts need to really think about, is this the best way to have judges and juries in a lagging way, sitting in judgment of the reasonableness of a technology decision 3 years before on which reasonable folks could disagree?
Laurie, do you have any?
No, I think you're right. I mean, part of the problem is that technology is evolving and litigation lags, and so you're looking at the state of technology 5 years later and trying to determine, well, what was the correct standard of care to apply when, frankly, the standard of care is moving on a much faster pace than it used to when we're looking at traditional, experts in tort and what's the correct standard of care when determining whether somebody's negligent or at fault. So just refreshing my reading of some of the cases, it is really, I think your point about are we going to have special masters, or how are we going to bring some of the, I've been in the field of intellectual property, it's the same kind of concern, right? How are you going to bring the technical expertise to the courts and to the jurors in a way that makes any sense for the system? Very complicated.
Which, by the way, I think the court just heard or decided, I can't recall if it came out last week, a decision about the venue selection in patent cases, which has gotten really quite focused on a couple of favorable venues. And is that the way we want things done? Those are hard questions for folks that look at the federal judiciary, at least, to say, should we have specialists or should generalists do this? But in this space where you're going to have multiple defendants potentially, or a defendant who's going to need to bring in other co-defendants or other third parties, I think it gets very complicated. And I get concerned about the effect on companies that need to work together. When you're in litigation, you're necessarily more constrained and cautious. And I think that doesn't create the kind of long-term benefits to the ecosystem of everybody sharing stuff rather than hunkering down and trying to win their case in the short term.
So, add a couple thoughts. I think the traditional framework, I guess, that the one we already have used as new applications, not just in technology, just in business and manufacturing for decades, is that ought to be the default or the starting point for looking at liability issues in the future, whether it's negligence, fraud, product liability, whatever it is. We shouldn't solve it as a securities lawyer. 10b and 10b-5 are pretty good. We don't need a bunch of new fraud laws. Let's just enforce what we already got. Having said that, I will add that I was talking to somebody the other day as I prepared for this and was thinking about this, and he said, what we don't want is PRP, potentially responsible party, strict liability to everybody involved in this chain, like we have in the environmental world in some cases, right? That kind of, if anybody's involved, we're just going to allocate responsibility based on however you do it in the environmental context. I don't think we want to head there. That's certainly a precedent that exists in a narrow context today, and we certainly don't want to head there, I think, when it comes to technology.
Right. Vic?
Yeah, well, I had sort of two thoughts on this. One is that I mean, these are all ones and zeros, right? We can tell from a security standpoint definitively exactly what happened. We can, right? There's technologies out there that let us do that. That doesn't necessarily translate to who's to blame, though, right? Meaning that let's just say there's a flaw in some IoT device, and it gets exploited. Well, configuration oftentimes has something to do with it. There's the battles that we fight all the time are around companies that will, when you have two choices, a more secure and a less secure choice of configuration, and the more secure choice does not harm. Let's say 99.9% of the people are not even going to know it, but they'll be secure. That they're worried about the tech support costs at the back end, so they make it less secure, so that they get fewer support calls, right? And that's where I think you can start talking about there may be potential liability for folks who knowingly reduce security for the sake of other conveniences, right? So I do think that you can technically tell where it is, where the problem was. B is that there's probably going to have to be a lot of education, and I know this is not a Torts solution or a congressional, nobody's going to pass a law around it, but there's going to have to be some education around it. And sort of the third thought is, if you remember, I'm old enough now to remember back when PCs first came out, everybody was making a PC, right? When the internet first started, there was thousands and thousands of ISPs. How many are there now, right? We're seeing the same thing with IoT. I don't think that anybody with a few $100s in a garage. I mean, to your point about a $300 sensor now can do the LiDAR, right? Anybody can do it. That's not going to be the case. If I look out 5 years, 10 years, there's going to have to be consolidation, and market forces are going to come to bear if there's that much of a business opportunity to raise the bar and make it harder for other folks to get in. So now you've got fewer players, which means that hopefully those players can be held to a little bit of a higher standard. Does that make sense? So meaning there's a gap we're in right now that I think the key is keep the trial lawyers from making a mess of it, right? But if you look out several years from now, the problem largely solves itself, I think.
Okay. Well, I appreciate that. I specifically asked that question because in a recent California State Senate hearing, Consumer Watchdog, which is a trial attorney affiliated organization, suggested that given the complexity that strict liability is actually the way to go because it would be impossible to figure out who is at fault. So I do think we have to give some thought to the answer to that question to push back on that. But I'd love to questions from the audience for the panel around the subject. Oh, sure.
Well, the VMware Edge product framework that I talked about earlier is an open source solution, and I think the thinking there is obviously if you open source it, you get hopefully a lot of contributors to enhance and manage and improve security. I'm not sure that it necessarily doesn't change the liability picture. In other words, if Jim's company decides to incorporate that software in his product, company's product, I mean, they're going to have to deal with, the security and safety and vulnerability issues that arise from embedding that software in his product. And in that case, there's nobody, as a matter of contract or as a practical matter, who do you, try to shift that liability to? I mean, I think that's shifting contract liabilities, indemnities, warranties, and that sort of thing is a pretty blunt instrument in that context, because it really wouldn't achieve his purpose of finding somebody's, pocket to tap into in the event of a failure of the product.
If I could add one thing, I think the open platforms and that complicates the ability to update and patch, and I think that's something that policymakers need to understand that I don't think they do, that when you're looking for, one neck to choke on a particular issue, when you've got, say, like the Android ecosystem is incredibly complex, and it's not as simple as, hey, handset manufacturer or network operator, go fix this, because it allows for so much variation in software and operating systems, and that's a good thing, but it does make the accountability a little bit more challenging and the speed with which things can happen a little faster. I'm curious if you share that view, but it's something that I don't know that the policymakers really get.
No, I agree 100%. If you think about Android, it's a perfect example because it's so fragmented. It's used by carriers. Like, let's say you get an HTC phone. On Verizon, your code base for Android will be different than if you get it on AT&T or if you do Deutsche Telekom, right? And these, which means that there's no, who's responsible for updates? In theory, you'd say, well, the carrier is. Well, the carrier doesn't want that, right? And so the open source, all it's doing is, in theory, I guess you could say that there is no liability for anybody because nobody's responsible, but I think that eventually someone's going to pierce through that and say that was really dumb that you used open source when you knew you couldn't keep it up to date. Well, I don't want to, but if you're a carpenter, you're responsible for the tools you use, right? Python's a tool. So whether it's open source or paid, if you're the one building the house and it falls over, because you used the wrong tool, then I think that's probably, I don't know that open source is going to solve your problem there. Right.
Any other questions? Oh, yep, good.
You mentioned that policymakers are not well educated on these kinds of issues. And do you have any ideas about how to bring the government up to speed? For example, should there be a Department of Technology in the federal government? Would that be a good thing or a bad thing?
I'm not in favor of creating any new departments in the federal government. And I'm sure the chamber isn't as well. But the bank shot here is this is where CTEC, I think, and ILR and other industry groups can really help policymakers, some of whom are very savvy. But I've found of my clients, very few companies want to come up by themselves and say, hey, this is how we do things, and this is why it's really hard. But someone like CTEC can tell that story to policymakers to say this is a lot harder than you might think without having one company imperil itself by having to be the sacrificial lamb to go up and talk about themselves, which people are genuinely fearful of doing. But I think folks do need to, there's folks on the Hill in the IoT caucus, the IoT working group, the folks I've talked to are hungry for this information, and I think it's a great time for the private sector to be telling them this story of these complexities and what innovators are struggling with, writing indemnification clauses and trying to figure out how to pass down privacy consents. And it's very complicated, and I think the policymakers want it, and I think that's the best way to keep them from regulating, which would be suboptimal.
So actually, I have a question, Megan. So the Digit Act, the pending legislation around Digit, do you think that will achieve that result?
I think that's the goal that it has, is its sponsors very much want to, right, I talk to my friends on the Hill who are deregulatory as a philosophical matter. They don't want to regulate, but they are also quite concerned about consumers in this space. One, there's harms that can happen, and whether you're Republican or Democrat, if something terrible happens with a consumer device, you're concerned about it. I think they're trying to set up a way to get smart and figure out some of this before reflexively regulating, and to try and bring together some of the disparate regulatory agencies who are all sort of churning on this issue because it touches their equities and they're not really sure what to do. And there's a lot of fear of fragmentation, that these federal agencies are just going to start doing things on their own, and the private sector is sort of playing whack-a-mole with a lot of that.
And also to just answer, I don't know if this is an answer, but in my last job I had responsibilities for all 50 states. And something that is clearly happening, legislatures used to be very dominated by lawyers. Those numbers are falling, but the numbers of scientists and engineers, software company folks that are actually getting into public office is going up. So there is some hope. Our Secretary of State here in California is an MIT grad. So I think that it is on, coming upon some of our organizations to encourage, tech savvy people to get involved with public service. So,
For instance,
Both-
Congresswoman, I'm sorry, go ahead.
Yeah, both the House and the Senate have created informal IoT caucuses, bipartisan. They want to get, just as Megan has said, they want to get smart about this, learn more. Both the congressmen as well as their staff, especially their staff, I might add, are very eager to learn more about this. They're not, they have different philosophies as they approach it, but nobody's trying to hurt anything.
We spend a fair amount of time up on the Hill, not talking about the legal aspects of things, but about the technical, right? Meaning when I go there, whether it's a Republican or Democrat, it's not to take a policy position, but to say, here are the facts, right? And I think they've been very open and eager. I'll say that there are maybe a handful of congressmen that are tech savvy out of the several hundred. I don't know if there's any senators that are. They've got some staff that can be pretty good. Commerce in particular actually has some very strong staff when it comes to cybersecurity, which is interesting. But the challenge that they're seeing that I hear all the time is, let's just say the automotive industry will go and they'll have some idea for how self-driving cars and vehicle-to-vehicle communication should work, and they don't have the ability of determining, is this real or is this smoke, right? And that's probably the single biggest challenge I see from their perspective, is that any industry can come in or companies can come in and say something that may technically be the equivalent of waving a magic wand, and they can't tell. And so you could make a specious argument for some sort of legislation based upon this magic wand fairy dust that could take things in a completely bad direction. And I think that's, I'm very empathetic to those folks, because I feel for them. They don't necessarily have the people or the background themselves to be able to determine what's real and what's not. So there is a huge role, I think, for CTEC, et cetera, to get involved, to help educate, because that's otherwise things can go haywire pretty quickly.
all right, well, I think we are out of time, so thank you to the panelists for a great discussion. We appreciate it, and
Thank you. Thanks very much.